Okay, I think we can start. Welcome back. So before, in the previous panel, we discussed the net neutrality, fair sharing in telecom investment, and overall this evergreen topic of interaction between competition and regulation in the telecom sector. Now we look at the pharmaceutical sector, specifically at the topic of excessive pricing, which is something not new. It's there for a very long period of time. And it's there in the light of the United Brands test since 1979. The Court of Justice told that in the famous ruling that a price is in breach of Article 102A when it's excessive, when the difference between the price and cost is excessive, and this is the second limb, which is cumulative with the first one, the price is unfair in itself or unfair when compared to competing products. The Court of Justice also emphasized that other tests are also possible. A number of competition authorities have applied the so-called benchmarking approach. They basically have compared the price charged by the dominant firm with the price of competitors for similar products, or comparing the price charged by the dominant firms in different geographic markets or to different customers. The court has never clarified exactly what difference should be considered excessive and in breach of Article 102.8. Clearly, the price, let's say, should be excessive for a very long period of time. So, let's say, should be significant and persistent, the price increase. And the Court of Appeal of England and Wales in Pfizer Flims also emphasized that since this type of test is quite uncertain, it should be verified by the competition authority under multiple possible tests. This is the advice, let's say. So investigating excessive pricing is not easy. Any competition authority faces a sort of dilemma. So on the one hand, the question is, what is excessive? What is unfair? If there is at least one customer ready to pay the price, then the price is not excessive. In the long term, a very high price can attract new entrants in the market, so the market can self-adjust. And by sanctioning excessive pricing, perhaps the competition authority will harm the incentive of the dominant firm to invest in its structure and in innovation. This is the traditional view, and for a very long period of time, because of this argument, there have been very few investigations by competition authorities in this field. This view, in my opinion, has changed in the last years. There's been more recognition that some products are, let's say, indispensable. The consumers have very high, almost unlimited willingness to pay, even in the presence of very high prices. So the demand is not elastic somehow. That we can have certain sectors, certain industries where we have either legal or de facto monopolies, where basically the market cannot self-adjust, even in the presence of high prices, new entrants are not possible. And rather than investing in innovation, perhaps the dominant firm can actually use these extra profits for rent-seeking behaviors. What about the pharmaceutical sectors? So, to some extent, the pharmaceutical sectors share some of the characteristics mentioned in this pro-enforcement argument. The demand of drugs is inelastic, is clear. So when we buy certain drugs because are, of course, very important, indispensable for our health, we cannot live without them, especially for chronic disease. And for most of the drugs, we have a sort of information asymmetries. So consumers buy certain drugs because they are prescribed by the doctors, not because of price competition. At the same time, research and development is extremely costly, long, and important in this type of industry. It's rewarded via patents and temporary monopoly rights for 20 years. which exceptionally only in the pharmaceutical sector can be extended via supplementary protection certificates, so an extension of the patent rights to recover the years needed for the pharmaceutical company to get the state authorization and the patents rights. And for some, let's say, rare disease, it's also possible to get the so-called orphan drugs. It's also possible to get an extra, let's say, patent rights. So to some extent, this high investment in research and development and also the patent rights, which can be extended beyond the traditional 20 years, can also represent a sort of entry barriers in this market. It's also a type of industry characterized by heavy state intervention. For most of the drugs which are prescribed by doctors, we see either a retail price cap or a reimbursement from the side of the healthcare fund. What is the impact of this sort of regulation, state intervention in market dynamics? So clearly this increases the inelasticity of the demand, in the sense that if consumers don't pay by themselves the price, or they pay only partially the price, they are less willing to switch from one drug to another one because of high prices. And also this changes the price and the availability of drugs in the different national markets. So de facto for many drugs, we don't even have a sort of internal EU market, but still national markets. So during the last years, there have been a number of investigations by a number of competition authorities sanctioning excessive pricing of certain type of drugs. In these slides, I have mentioned the four most important and well-known cases. The Pfizer-Flynn case, where the case concerns the excessive price of phenytoin sodium capsules, so a well-known and off-patent drugs used in the United Kingdom to cure epilepsy. The CMA decision dates back to 2016, but it was then quashed on appeal by CAT and by the Court of Appeal. Very recently, the CMA has published a new decision, and the case is again on appeal at the Competition Appeal Tribunal. We have the two Aspen case, decided first by the Italian Competition Authority and later by the European Commission, which also concern, let's say, off-patent drugs. The remedy was different. In the Italian case, was an infringement decision upheld court. For the European Commission, it was a commitment decision. And then we have another interesting case, is the Ledian case, sanctioned by the Dutch Competition Authority in 2021. Why it's different? Because it's the only case which concerns orphan drugs, so a type of drug covered by patent rights. So I cannot go into the details of the four decisions, let's say. You can read the four chapters of the books dealing with the four cases. But I can briefly, let's say, discuss what are the common features among these four cases. So first of all, we are talking about rare disease. Okay, the demand is very limited and extremely inelastic. So consumers are not willing to switch to a different type of drug when we are talking about drugs which are curing cancer, the metabolic disease, like in the case of the Ledian case and so on. We are also talking about, with the exception of the Ledian case, off-patent drugs. So off-patent drugs are generic drugs produced after the end of the patent rights, of the 20 years patent rights, plus the supplementary patent protection certificate. So in theory, when the market is open, when there are no legal monopolies, you would expect the price going down. But in all these cases, we saw exactly the opposite. So both in the Pfizer-Flynn case and in the Aspen case, these generic drugs have been rebranded, and from one day to another, without any, let's say, specific reasons in terms of content of the drugs, the price has increased of up to 1,000%. In the Aspen case, another sort of evidence of the unfairness of the price, of the excessiveness of the price, is the aggressive negotiation strategy followed by the company with the healthcare authority. That basically the company threatened the healthcare authority to withdraw the medicine from the market in case it did not accept the proposed price increase. What about the legal test? So also something very interesting is that the four cases rely on the United Brands test, the old test of the Court of Justice from 1979, but many questions remain open. So what is a price unfair in itself? What is the role of benchmarking? Is it possible to compare, let's say, the price of different drugs to identify a proper benchmark or not? I don't have conclusions, but similar to Anna, I have a couple of questions addressed to our panelists. First question is very, I would say, general, and the question is whether competition authority should indeed investigate excessive pricing cases, or they should better leave the task to intervene state regulators in terms of pricing regulation. What is the role of an exploitative strategy? So we know that the concept of abuse is an objective concept, that strategy intent is irrelevant, but actually, let's say, the strategy of the company was an important element relied in the Aspen case, in the Italian Aspen case, for the competition authority to show that we had unfairness. Then question is whether this type of investigation should only concern off-patent drugs or also medicines covered by patent rights, where we clearly have an overlap with IP, like in the case of orphan drugs in the Ledian case. And then I would like to ask our speakers what's their view about the United Brands test, if it's possible to define a price increase as an unfair in itself, and what is the role of benchmarking. And finally, I think a good question is about what is the incentive, or I would say deterrent effect, of commitment versus an infringement decision when we talk about an excessive pricing case. So we have today 4 speakers with us. Margherita Colangelo is a professor at University of Roma Tre. She has extensively written on the topic of excessive pricing in the pharmaceutical sector. She has also contributed to the book. Ilan Acker is an official at the Dutch Competition Authority. He's also been involved in a number of investigations, so he brings, let's say, the enforcer perspective to the debate, and he's also one of the authors of one of the book chapters. Baptiste, one of our hosts, well known in the room, he brings a sort of practitioner perspective to the debate, and has also quite a lot of experience in this field. And finally, Adam Scott is a judge at the UK Competition Appeal Tribunal. He also wrote one of the chapters of the book, and he will bring a sort of judge perspective to this debate. So we have, I would say, 4 speakers who have a different perspective on this topic and who can somehow contribute. So I would slightly change the order of the speakers. So I would go for a first round of interventions. I will first give the floor to Margherita, who unfortunately cannot be with us today. So, Margherita, what is your view about the first question? Should the Competition Authority investigate excessive pricing cases at all, or under which circumstances?
Thank you, Marco. Can you hear me?
Yes, we can.
Yes, okay. So thank you very much. First of all, let me thank the organizers of Macrobota for the invitation to join, firstly, the book we are presenting today and to join the panel of this event. I also apologize for this late inconvenience that has not allowed me to be present in Brussels. So I will deal firstly with the very first question. And so the role of regulation, price regulation, and the state versus the role of national competition authorities. We know that regulation rather than antitrust is typically dealt with pharmaceutical pricing, and that, of course, price regulation is inherently distant from antitrust policy. Also, Marco has stressed some of the peculiar features of the pharmaceutical sector that are strictly linked to price regulation in this area. As Marco said, the traditional, let's say, majoritarian approach supported that the intervention of antitrust agencies in excessive pricing cases should work as a last resort. And basically, I think that current practice, in my view, still supports this finding, and the idea that antitrust intervention can work as a fact-specific tool in limited circumstances rather than be a viable solution to high price increases in the pharmaceutical markets. On the other side, I think that these cases, together with others recurrent in the pharma sector, report the need for regulatory reform and, of course, for more, let me say, more creative regulatory solutions. So in such respect, what can we learn from these cases? I will take mainly Aspen as an example. It is the only one decided by the European Commission. It is also the very first investigation, excessive pricing investigation in the pharma sector conducted by the European Commission. However, this applies also to the other cases. As a matter of fact, both the Aspen and Flynn cases dealt with the increase of several 100% in the price of hold of patent pharmaceutical products that the defendant companies bought from third parties, which had developed them long before, while the Aspen drugs, the Cosmos drugs, can seem prima facie different, being brand name drugs, and the latter, the Pfizer-Flynn case did with a generic, they proved to be very similar, as the investment made for their development had in both cases already been recouped. And for my understanding of the case, despite some peculiarities, also the Lydian case shares some of these features. So the common feature, in my view, is that they are old, off-patent products, in the sense they are not innovative products. Often we are dealing with post-acquisition strategies where in some way or another pharmaceutical companies have tried to game the regulatory system and to avoid the intended objectives of price regulation. In the European investigation, for instance, again, with regard to Aspen has resulted to have adopted a pan-European strategy, including, as in the Italian investigation, the aggressive negotiation strategy towards the competent agencies, arbitrage between different pricing systems, and strategic sequencing of price increases have been put in place in order to defeat the external reference pricing system used by member states. Moreover, in the Italian investigation, the pharmaceutical company took advantage also from the existence of a regulatory loophole, allowing the company, if the negotiation of prices with the regulator were unsuccessful, to have its drugs as delisted and so classified in the class of non-reimbursable ones. In other words, the Italian Medicine Agency was somehow held hostage to the negotiation strategy enacted by the pharmaceutical company and turned out to have no adequate bargaining power to counter it. In Pfizer-Flynn, the medicine at issue was debranded, and this, according to the rules applicable at the time of the infringement, permitted the pharmaceutical companies to put the medicines outside the statutory price control, which was not applied to generic medicines. So these cases, in my view, first of all, Aspen, are significant not only as excessive pricing cases, but also as they recall a sort of regulatory gaming behavior, which we know is particularly frequent in the pharmaceutical sector. Now, in this context, in the context of these cases, there is no room for possible concerns for an overlapping or trespassing by competition agencies in the area of competence of regulators. And antitrust intervention seems to have served as a help for regulators rather than acting in conflict with them. Now, given the pharmaceutical regulatory system, where in general we have an extensive price regulation based on national public policy, of course, with a specific difference between the states, regulatory failure that results in unfairly high prices could be properly addressed through regulatory intervention, including remedy to the existing failures. So it is clear that when there are gaps or loopholes in the sectoral system governing prices, competition enforcement is called to act. In this perspective, antitrust intervention, where needed, might work as a pathway also to help regulation addressing the failure. This is what we have observed somehow in the UK, where the loophole in the sectoral regulation has been addressed with an act in 2017 that has introduced rules to give the governments additional powers to control the price of drugs, particularly on bread and generic products, and to prevent manufacturers from debranding in order to significantly increase prices. Moreover, I think that excessive pricing cases, such as those that we are commenting today, may give room for a broader consideration of viable options to be explored, including, on the one side, the provision of alternative bargaining strategies between the buyer and the seller, and the improvement of the use of value-based health technology assessment when evaluating medicines, as also the European pharmaceutical strategy supports. On the other side, I think that the option of enhancing the coordination between agencies and national competition authorities should be considered. So the issue could be how to find an appropriate way of implementing, let's say, their complementary role where needed. Again, then Aspen gives rooms also for a tentative answer on the second question, as a peculiar aspect of this case concern the strategy, so the means adopted by the undertaking, to which, as a matter of fact, the antitrust decision give particular relevance, despite this element is not essential for the finding of unfair pricing. So if we look at both the Italian investigation and the European one, it appears that due to the features of the case, a combination of several factors, in addition to those strictly related to the excessive pricing test, is taken into account, and somehow strengthens the serious concerns of the competition enforcer for the abuse under investigation. In particular, in the European investigation, the Commission took into account Aspen's strategy at the second stage of the test. And in doing so, the Commission recalled the opinion of the Advocate General Val in the Latvian case. And it affirmed that the analysis that has to consider also the dominant undertaking's conduct and its economic motives, and that the objective reasons behind this pricing policy are highly relevant. I could not find a similar statement also in the judgment by the court in the same case. I think that, however, this is somehow can be again related to the aspect I mentioned before. So in the sense that I agree with the view of those who argue that as regulatory gaming is ultimately about the corruption of the underlying regulatory regime, this could also somehow explain why intention may become somehow a critical, despite non-essential component of the theory of harm in these investigations. Thank you.
Thank you, Margherita. Thanks a lot. I would now like to give the floor to Ilan. Do you agree with Margherita? And you need to click.
This one? Yeah, absolutely. All right. So I was saying that I do agree to a very large degree with what Margarita just said, and I think where the differences are mostly in the field of, but they're not so big either as well, and that is how do you look at the role of IP. So in the book chapter that I wrote together with my colleague Wolf Sauter, we focused on two issues. The first being this application of excessive pricing in the context of does it have the potential to hamper innovation? And the main point we make there is, well, it does not need to, as long as you take the degree of risk and innovation as an essential part of the assessment. Once you do that, there are actually no essential reasons to exclude any kind of patented drug, including because, well, you could argue an orphan indication is not strictly speaking a patent. But even having a patent does not necessarily mean that the actual medicine, bringing it to the market, involves a large amount of risk and innovation. And we see that in the behavior of evergreening. And evergreening could, at least in theory, potentially be addressed also through excessive pricing. Is that easy? Obviously not. And that is where I think the differences in practice are not so large, because clearly if we are talking about a real innovative product, then as a competition authority, you would have to, the bar is really high if you want to prove that your intervention would not lead to harmful consequences. So the second element on a rather different level of abstraction was like indeed on similar to the first question, is like, how should we view competition law and regulation? Are they complements? Are they alternatives? And clearly we think they are complements, and to a large extent along the lines that Margarita just mentioned, that that often if there is a need for investigating a potential excessive price, that in itself you could argue points already to a possible regulatory imbalance, and that is something where antitrust and regulation could potentially work together very well, actually. So yes, it is useful to think of what situations regulation deals well with, and what situations antitrust. And in general, you could argue that regulation deals well with structural and predictable problems, whereas antitrust is more flexible, but obviously exposed and also very high standards of proof. So I wanted to go quickly over kind of 3 examples where antitrust cases do point at regulatory weaknesses. Two of those are excessive pricing cases in the pharmaceutical industry, and one is an exclusion case. The first one I'll be very short on, and that's Pfizer-Flynn. I'm short on it because Margarita already mentioned it, and Adam is surely going to say some words on it. But there you could clearly see that it's actually a bit of repeating the point that Margarita already made, that the Pfizer-Flynn case points actually at the regulatory gap there of the voluntary regulation scheme and the possibility to to debrand the specific drug and kind of escape the price regulation. Then I'll go to the Dutch lenient case. Maybe I should add that the countries you mentioned also outside of the EU though, but Israel also had a decision in the lenient case. What I think is crucial there is that the lenient case points at what what I would argue are weaknesses in the orphan regime as we know it. The orphan regime aims at stimulating drugs for small patient groups, but what we see in practice is that it also creates the possibility to monopolize and increase prices on for well-established and repurposed drugs. And it would be very fruitful to take such a competition case and think of, hey, what are thinking from the specific case, what could be regulatory solutions? And then you could come up with things like, hey, maybe we should target the incentives at where the medical need is. Maybe we should tie certain obligations to having an orphan designation, such as whatever that may be. But you could think of obligations to make the drug available in the whole EU for a reasonable price. Kind of kicking the can, because then you would have to figure out what is a reasonable price. But if we were to think about those kind of solutions, allow me to go over one non-excessive price case, and that's the European Copaxone case. It deals with two elements, but here I focus on the use of the pharmaceutical company Teva of the fictional patents and bringing them to court, knowing that the patents themselves are probably weak, but just before the court is about to rule on it, the patents are withdrawn and a new patent is enforced, and it's a strategy used to prolong the exclusivity. And here it would be also worthwhile to think of regulatory solutions, like should it maybe in certain cases be possible for a withdrawal to be denied, for example. So yeah, what do we learn from those examples? I think certainly the idea is not that the NCA should have chosen for the regulatory fix instead, but the idea, apart from the fact that competition authorities do not have such an authority, but it shows that the antitrust cases and regulation can strengthen one another. Well, another unimportant detail is that regulatory changes can, of course, only have an impact looking forward, whereas antitrust cases, we also look backward. Like to make the argument on the colliery side, any expectation that as a result of applying competition law, that could ever be a structural solution for unfair pharmaceutical prices, that'd be that be simply misplaced.
Thanks a lot, Nilan. Let me now give the floor to Baptiste, and let me remind those of you connected via Zoom that you can ask a question via the Q&A. So you can chat you can write your question, and after the first round of intervention, we'll collect some questions from the audience in the room and from those of you connected via Zoom. Baptiste, what do you think about the United Brands test and its application to the pharmaceutical sector?
Thank you, Marco. Does this, yes, this seemed to work. Okay, thank you. Thank you indeed, Marco, and also my co-panelists for their interventions so far and to come, of course. I would indeed like to say something about questions 4 and 5, basically the second limb of the United Brand test, which is a lot older than I am, which focuses on the unfairness of excessive prices. So obviously unfairness and the first alternative of the test, which is that prices could be unfair in itself, raised the question, what does it mean for prices to be unfair in itself? And one possible interpretation which has been put forward is that it is actually the excessiveness of a price which causes prices to be unfair. And we see that in part of the interpretation, also in the Commission's Aspen case, which as part of the unfairness analysis, or the unfairness in itself analysis, also looks at the disproportionality of the price increases and the magnitude of the excessive profits. But in my view, it would be that interpretation is slightly problematic, especially if that's where the test would stop. Because ultimately, if excessiveness informs unfairness, then what is the difference between the first and the second limb of the United Brands test? Does that essentially mean then that we go after all prices which generate high profitability? I don't think that can be the case, because, well, if we look at other sectors, for example, well, we see that high prices or prices with high profitability are perfectly acceptable. I mean, we look at the energy sector, where the market model is essentially based on the fact that the prices are set by the marginal production facility. So solar panel plant can charge electricity prices set by a gas producing plant, which obviously operates at operational costs which are multiples of that solar panel plant. And that is accepted. Likewise, in the aviation sector, I think some of you have flown in on an intra-European flight. The price difference between a business class ticket and an economy class ticket, they're hardly really explained by that one extra glass of champagne that you get. But still, that is accepted. So ultimately, the price difference, that can't really be it, because, well, essentially that would collapse the entire United Brands test into one idea, and that is, I think it was John Davis of Compass Lexicon who said it. It just means that prices are too damn high. That can't be the legal test. So the alternative, which you also often see, is that prices are unfair if they bear no reasonable relation to the economic value. And again, that raises the question, what is the economic value of a product? And when can we say that there's no reasonable relationship to it? Now, economic value, that was a debate in 19th century economics, and I've been told that has been resolved by now, in economics at least, to the extent that it's now accepted that there is no such thing as an intrinsic economic value. And that has also led the Competition Appeals Tribunal in the 2018 case to state that it is actually a legal rather than an economic concept. Excellent. So we don't have to look at economics, no econometrics, no maths. I think that's the dream of any lawyer. But then what does it mean, obviously, from a legal perspective, this concept of economic value? And then we can look at, obviously, what the Commission and the courts have said, and in addition to the Latvian copyright case, which was already mentioned by Margherita, we can also find guidance in the Commission's Scandlines-Sverige decision, which state that we also have to look at other non-cost related factors. In that case, it was to do with the demand in the sector for ferry services in the Baltic Sea. But I think we can really see that as a sort of broader invitation to look at the economic context and the manner in which certain price increases have been implemented. And I think both Ilan and Margherita have already mentioned a lot of those elements in the cases they've mentioned. I mean, if we look at the Commission's Aspen and the Italian competition authorities Aspen decision, what we see it is an increase of the prices of an existing product, existing drugs, which was actually profitable without any really, not really linked to any improvements or additional investments, which was carried out in a coordinated manner across Europe with really the purpose to circumvent the regulatory external pricing referencing regime. There's the whole idea as well that Aspen realized that it was only able to do so because of a lack of competition and was causing a significant adverse effect on patients and the welfare system. And the same actually goes changing the things that have to be changed in Pfizer Flynn, where you see that the company adopted really a strategy using the regulatory system, in that case by debranding their product, so they could basically remove their product from the regulatory price or the price regulation in order to change or to increase the prices exponentially without really having any cost increases, any improvements or additional benefits. There again, we see that the companies were very well aware of this tactic because Flynn was actually added to the distribution chain there, as the internal investigation of the CMA revealed, with the whole purpose of avoiding the reputational risk that those price increases would cause on Pfizer. And again, as well, the regulatory regime in the UK, which at the time lent itself for this tactic, was also used to selectively implement those price increases, is basically the same tablets, the same capsules, I need to say, were manufactured in the same facility in Germany, were sold elsewhere in Europe at vastly lower prices. And again, there as well, the competition authority took into account the adverse effect on the patients and the welfare system. The last set of cases I want to mention, because, you know, as the only case where the Belgian authority has looked at, I also need to say something about the Leadian case, although the Belgian authority, as one of 5 then, I guess, has now decided not to pursue the case, as the Auditor General has stated last 2 months ago. But there it's often argued that, well, this is really a different type of case because it concerns orphan drug specification. But I don't really agree with that. I think it is actually more of the same. It is, again, a strategy to increase prices using the regulatory regime and without any underlying improvements to the therapeutic value or the investments of the company concerned. So what we see is really that in all these cases, context and the manner in which prices are increased has played an important role. And I think it has to play an important role. So I would perhaps go one step further than Margherita, because if we don't look at context and manner and require that as one of the conditions under the unfair test, what we essentially would allow is that authorities can prosecute any company whose prices it considers to be just too damn high. I think, on the contrary, excessive pricing cases should really be limited to those exceptional cases, well, hopefully exceptional cases, where there's something else going on, like the improper use of the regulatory regime, an abuse of the loopholes in the system, or really like a threatening of a withdrawal from the market, which would really harm the patients. Because I think anything else would really transform authorities into ex post price regulators. And I think, well, we all agree that that is not really what we would like them to do.
Thanks a lot, Baptiste. I would now like to invite Adam to the podium so that he can present. Yes.
disclosure. Margarita mentioned the pharmaceutical pricing regime in the UK, and I have to disclose that I took part in a review and I was funded by Merck. And I have to tell you, I told the pharmaceutical industry they were doing very nicely out of it, and the last thing they needed to do was to rock the proverbial boat. I also have to disclose that whilst at the University of St Andrews, I did some work for Pfizer. I'm not going to tell you what I did for Pfizer, but because the publications are anonymized, but I did. And therefore, in terms of hearing cases, I steered clear of pharmaceuticals at the CAT. And as you'll appreciate, they're back with us, Pfizer and Flynn. So I'm going to summarize the grounds, but I'm not going to say anything else because it's sub judice. And there's a guard clause in there about what I say. So, costs, comparables, and fairness. United Brands is now rather old, and it's bananas, and it's very different to pharmaceuticals in many ways. First pharmaceutical case we had was NAP. And in NAP, the contrast was between the price of these painkillers in hospital, very cheap, with the result that NAP had a 95% market share, and what happened when you left hospital, when it went up orders of magnitude, and they were able to make an enormous profit because you were taking this drug and you went on taking it, and it was very profitable. And in NAP, we approved a variety of methods based on costs and comparables. And that got approved by the Advocate General in Latvian copyright. Now, mention was made of Advocate General Val, and one of the great advantages of being an Advocate General is you can be more expansive than the court generally is, but not necessarily authoritative. So, how are competition authorities, let alone courts, to handle the sheer volume of evidence that can be thrown at them by parties? I am on record as having said the task of the authorities must not be rendered impossible. And I think that's very important. As we've discussed, fair and unfair are qualitative terms. They're hard to define. We don't have a definition. And strangely, so far at the tribunal, we haven't had a professor of philosophy. Now, my colleague at St Andrews, John Broome, left being an economist and became a philosopher because he was concerned with the value of human life and how we were taking decisions. When we had a conference of judges in Paris a few years back on pharmaceuticals, one of the questions that came up is fairness between whom? See, you imagine that Ilan here has a rare disease, so we're going to spend a fortune on keeping him alive. And sadly, I'm afraid that the 10 of you at the back of the room are going to die because we can't afford to treat you at all. So fairness, we have to ask ourselves, fairness with whom? And judges, of course, have to deal with both procedural fairness and substantive unfairness. And so be careful when you look at decisions we make as judges, because sometimes the reason why an appeal is successful has more to do with procedure than substantive law. So I'm not going to go into these in detail, but you ought to know, because this is the sort of complication which the tribunal is handling. So Pfizer say that the CMA ignored real-world indicators. Notice the prejudicial wording of real world. In other words, they're very theoretical at the CMA. They don't really understand the real world. They're very narrow focused, you know. tied into the cost plus analysis. And in a sense, that contrasts with the QALY analysis. That's the quality of life analysis, that NICE, which is our National Institute for Clinical Excellence, and the whole issue of value for money, which takes you back to economic value. Excluding alternative methods, that takes us back to NAP and the variety of methods you use, procedural unfairness, and there's a penalty appeal. When it comes to Flynn, you've already had this mentioned to you, the theory is that the findings are tainted, that the returns are consistent with comparators. Now, you'll realize that what's going on, and my recommendation to you as those advising clients, is move your manufacture out of the EU, sell it to the party you've got going to do the distribution outside the EU, so they can then say, well, we only added a little bit to the price that we paid in the country outside the EU, and so we're okay. And they're arguing that pricing is in line with comparators, not out of all proportion. It's not high enough to be abusive. And also their risks are not captured, not recognizing economic value beyond cost plus and their role in security of supply. There's also penalty. So I mentioned what this is about, and the context for us is that, as in many cases, somebody has to make a decision on whether the drug should be paid for by the National Health Service. In other countries, it's whether it's reimbursable by the social security system. And somebody has to make up their minds on supporting it. And as we've seen, quite often the authorities doing that are in a weak position because they've got patients dependent on these drugs. And so, as I put in red, treating one patient may mean denying treatment to others. So what do we want? We want a healthy pharmaceutical industry. We want risks managed through regulated distribution. Now that produces the gaming that we talked about earlier on. We want innovation to continue. We want security of supply. And what we have is complexity. We've got complexity in partial regulation, in the way in which we do market authorization. We've got complexity in prescribing practices. I don't know whether you've been prescribed recently, but I've watched the doctor going online and looking at what they are being told to do. And quite often now, the individual doctor doesn't have as much discretion as you might like them to have, that they are being governed by what is coming up on the computer. And also patients are accustomed to particular formulations, and that can't be dismissed. So my particular focus is on old, out-of-patent drugs and drugs which are seemingly essential, or the formulation is essential. There are people relying on these, whether as medical practitioners prescribing or patients who've been stabilized on these drugs. There are the manufacturers and distributors who have leverage, and their power can be reinforced by both structural factors and behavioral factors. Don't underestimate the behavioral factors here. The way practitioners operate is a behavioral factor. And then, as I said, there are those responsible for procurement and reimbursement who are probably, in most of these circumstances, weak, which takes us back to the questions for debate and what am I meant to be talking about, which is 6. So that's the task for me. Task for authorities is heavy. Excessive pricing has not proved easy. There's a great capacity for appeals. but for the parties, there is considerable risk. There can be substantial fines, and there could be even more substantial claims for damages. Just to give you some idea, at the moment at the tribunal, we now have 60 billion pounds worth of claims under our collective action proceedings. So there's a lot of money out there. So what of commitments? Well, I'm really very keen on Margrethe Vestager saying a strong signal not to engage in abusive pricing. Because for me, the ideal here is that what people like us do results in people like us not having to do it. Because pricing decisions are made which are not excessive, but sensible. I was an intellectual property lawyer in my youth, and for 6 years, no matter for which I was responsible went to trial. That was because I settled them all on terms which were acceptable both to the patentee and to those who were infringing the patent. And I do believe that it's possible for reasonable people to reach a reasonable conclusion. So in the Aspen case, commitments offered, as the Commission said, a fast, comprehensive, lasting solution which produced both price reductions and continued supply. Now, what are the downsides? Well, breaching conditions can lead to fines on the 10% of turnover scale. And you don't need any finding of infringement. It's the breach of the commitment that counts. And the other thing, following the Gasorba case, is that commitments don't exclude the possibility of a private action in a member state, with which I should stop.
Yes, now it's working. So we can now open the floor for questions and answers. I would like to give first the floor to Anna, who will check.
So far we have one question from the audience, and the question is, has there been on the EU level any excessive pricing case where a competition law infringement was detected with a sector regulator's green lighting for such a price? A serious failure of coordination between a competition authority and the pharmaceutical sector regulation.
Okay, who would like to answer the question?
Maybe I can
Yes.
go first, I don't know. Well, if I have correctly understood the question, I think that we must clarify that in these cases, prices, at least in the case of, for instance, for Aspen, there is the case that I've treated more, the prices were adopted after the negotiation with the medicine agency. So at the end of the day, they were somehow accepted, but the point was that there was not really a choice from the medicine agency. So if this is the question about the fact that the price was green lighted by the sectoral regulator, I think that this is a clear example.
The others, Baptista, Ilan, do you also agree?
Yes, exactly. I think that that's the whole problem in the Aspen case is the imbalance of the negotiation power between, on the one hand, Aspen and then the drug authority, which was basically which had to care for these patients who were obviously dependent on the drug. So then it's rather, I wouldn't necessarily call it green lighting the price, but it's rather just a result of essentially a negotiation between the authority and the manufacturer.
Yeah.
Marco, if you are still collecting questions, may I add something on the commitments?
Margarita, can I?
Please, first Ilana and then Margarita again about the commitments.
Oh yeah, so in the Netherlands, still not that long ago, we actually had a system of open access for medicines and then there were negotiations after the medicines were already in the market. So you can imagine that the negotiation position of the government was quite weak at that moment. But still, now that that system is not that open anymore, you still have to deal with a situation where the bargaining power of the government to decide to buy or not buy a certain drug are in many situations quite limited, and that is an important context.
Thank you. Margarita, you wanted to intervene about the commitments.
Yes, sorry if I interrupt, but being remotely, I could not understand this point. Now, I was just elaborating on the issue of the commitments. Well, I found it peculiar the fact that the Commission decided to adopt a commitment decision in this case as an alternative to a prohibition decision, as we had in the Aspen case, in the national investigation, and also considering what was happening in the Pfizer Flynn saga before courts. So I see, of course, the advantages of having a quicker effect on the market, more tailored remedies, a swifter implementation by the undertakings. However, of course, also the Commission may apply, so Article 102 without an extensive economic and legal assessment. But this kind of decision provides no sufficient legal certainty, only a limited chance of judicial review. So for this reason, the recourse to commitment decision, I think that raises criticism in novel and complex competition cases. In Aspen, this precluded the release of a full assessment by the Commission, which would eventually be scrutinized before courts in order also to give further guidance to the industry and enforcer. That was needed, also considering what happened in the Pfizer Flynn cases, and that could, in my view, somehow have an effect in opening or not the way to next cases to be investigated. This is my point of view on this point. Thank you.
Maybe I would just like to also comment on the fact that well, obviously as practitioners, we very much like, especially if it's not our clients, infringement decisions and then subsequent court proceedings, because that gives guidance and then we know what to advise next time, essentially. But if we are advising our own clients, what we do see, and I imagine that's the same for authorities, is that commitments decisions have really efficiency gains in many cases. So from a pragmatic approach, I fully understand why these type of decisions are more and more common, let's say.
Okay, I see. Of course, there are different views. It's very difficult, let's say, to say whether they are good or bad. And I think it's very difficult to say if really they have an incentive effect for the dominant firm to change its practice in the long term. I think Anna mentioned that there is another question in the chat. Anna. Yes,
So
Anna first.
I will read the question from the chat. Any opinion on the relevant cost benchmark? In all of the cases, the latter has been ATC, but wouldn't it be more logical to use lyric, as that would be closer to how pricing would happen in a comparative environment, and more generally, have DG Comp endorse the benchmark? That's the question.
Who would like to reply to the question about the cost?
Average total cost and lyric.
Yeah, the cost
It's been endorsed by the DG Comp.
Ilan, the economist.
Yeah, an unsatisfying answer, but that I think in general be a bad idea to out of context tell you which cost model fits best. To give you an example, in looking at a drug with the orphan indication, it makes sense to take some more years into account. So you look more at internal rate of return. Whereas in Pfizer, Flynn, it makes more sense to look at the return in one specific year. So I think I would have to disappoint this person to come up with one definite model.
Them?
In the case of innovation, you have to recognize that looking at the whole of a pharmaceutical undertaking, you go through an enormous number of unsuccessful compounds which fail along the way. And so you've got the tension between the sort of approach taken in an overall pharmaceutical pricing regime and what happens when you're considering a very specific drug. And in the case of a specific drug, there are inevitably common costs, and you've got to think about how the accounting is being done. One of the advantages we have in the tribunal now is that we have accountants as well as economists. Accountants and economists are very different creatures. And so understanding how pharmaceutical companies do their accounts is also important. But this is quite difficult. In an overall sense, you need to think about innovation. And basically the expectation is that in the period of the patent and of the extension of that, you should be recovering sufficient costs to keep your innovation going, which includes the substances that fail to make it.
Thank you. I think there was one question from the audience, please.
Hi, everyone. Yeah, I had one question actually for all of you. First of all, thanks for the very helpful insights that you've provided. As you know, most cases all cases that we have seen so far have to do with stark increases of price over time, or stark increases that have occurred right after a drug was acquired by another company. Now, a question that I've posed myself is also, what do you do with a certain price that has maintained the same over the years, but has not been reduced enough? Could that be seen as an excessive price as well? Because there it's more difficult, because I think there you get more into the territory of price regulation, because what would that price have to be? And it also has to do with what has been said before, is that it's important to also look at the context as a whole and to look at certain strategies. And it will be more difficult to find a certain strategy where the price of a drug is maintained over time. So I was wondering how you would assess those facts.
Like to give it a try? Ilan.
Well, it's an interesting idea, and do I understand you correctly that you're saying that a drug is under patent, has a high price, then it gets out of patent, somehow competition doesn't get going and the price stays high? Is that the situation you're thinking of? So I could imagine, maybe the easy answer is, I could imagine it'd be interesting in such a case to know why exactly competition wouldn't come up. And I would think I would try to address that first if possible. But if not, then you might be onto something. But at this moment, I cannot really think how you would. It is a much harder scenario than when you see a price hike. But I also don't want to exclude it from being possible, what you're saying.
It's harder unless either somebody blows the whistle or you discover that there is behavior like pay for delay going on behind the scenes. And you may come back to this, Paul, because there are circumstances. I mean, I'll be honest with you. One of the things which has unnerved me in my life is that there are licenses that I arranged long ago under patents, which went on after the patents had expired for terribly good reasons, which I sure would have been defensible. One of the advantages in my youth was you could notify the commission of what you'd done and expect that it would be in the commission's pending tray for so long that they would never get round to investigating it. But no, you have to ask yourself, what's really going on here? And is there an anti-competitive reason why this price has been sustainable in what should have been a competitive market?
Yeah, I just a couple of words, but I think I fully agree with that. I think this goes a bit towards what I was saying about there needs to be something else going on. So I also think we don't necessarily need to look at it from an excessive pricing point of view, because indeed pay for delay or other exclusionary type of behaviors are, I think, a more obvious route to take for complainants or for enforcers. But it all depends on, I'd say, the context and the manner in which prices are, in that case, kept high. Yeah.
Yes. Anna, the last question is for you.
Thank you. I have a question to Adam. So when you discuss the incentives to have commitments or infringement procedures, as far as I'm aware, there's only one decision at the EU level imposing a fine for the breach of commitments, which makes me wonder, are the companies so compliant, or is it an issue of under enforcement in terms of monitoring? Because I think that if I'm a competition authority and I conclude a case with a commitment decision, then it's in the case on the superficial level, it's a win-win for everyone, right? So then if I also have to prioritize my resources, I would rather prioritize them using them for a new case rather than checking whether actually a firm is compliant. So if I'm a firm, then I may be more willing to offer commitments because I think like they are not going to monitor if I'm compliant.
So the first thing to say is that as judges, we have decided in the Association of European Competition Law Judges that we have to pay attention to commitments. And so commitments are going to be on the agenda for our discussions in The Hague in June. Now, in the case of Aspen, there's a trustee, Paul, is that right? So there's a trustee observing it. So there is a specific mechanism. Now, as I say, commitments are not risk-free. And as far as I know, we have yet to have a private action seeking to prove infringement where there has been a commitment. And that takes us back to what are we really trying to achieve? And really we're trying to achieve reasonable pricing, which doesn't then lead to either a need for infringements and fines or private actions. So I think there are mechanisms to ensure that commitments are pursued. And I would hope that private actions might follow that as well, that people knowing the existence of commitments would be keeping an eye on whether the commitments are being followed. We've had one appeal on commitments, which failed on technical grounds. And that had to do with the fact that when you got to paying for your wonderful new piece of electronic gizmo at many stores, they just added a small amount for an extended warranty. So you got the product very cheap, but there was this little extra. You will want the extended warranty, and so you paid quite a lot for the extended warranty. Now that proved to be undesirable. So commitments were taken. Now, our problem in the UK was we had one major retailer who gave you the extended warranty for nothing and was therefore not part of the commitments. and didn't get the advantage of the wonderful system that our National Competition Authority had arranged with the parties who'd given the commitments. And so the party who wasn't being investigated brought an action. Now, actually, it failed for technical reasons, but you've got this very interesting question of who challenges commitments at the stage of the commitments, let alone who challenges commitments if they're breached. But the hope is that you'll have a trustee watching, and anyway, private parties with an interest, an enforceable interest, can keep an eye. But we are, as judges, we're actually quite concerned about what is happening, but we're also concerned about settlements and what happens with settlements. But commitments are a particular focus at the moment.
Thank you. Thanks a lot, Adam, for this very interesting insight. And I would like to thank all the speakers joining today, the second panel. I think I would like to give the floor now to Jose Rivas and to our keynote speaker, who will somehow continue the discussion about excessive pricing in the pharmaceutical sector. Thanks a lot.